In a medical malpractice case in New York, how do you know if you're getting a good settlement offer? Would you like to know the answer? Come join me for a walk around the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. One of the best ways to know that you're getting a good settlement offer is when your attorney tells you, listen, I've done the research, I know the cases, I know what your injuries are worth, and I know that this is a great settlement offer. When your attorney comes back to you and tells you that this is a good or great settlement offer based upon his knowledge of the cases, based upon his knowledge of the case law, based upon his knowledge of what similar cases have settled for, as well as what similar cases have gone to verdict for and been upheld or reduced on appeal, that's the way you really know whether or not you're getting a good settlement offer. In these medical malpractice cases, in these accident cases, in these wrongful death cases in New York, you should know that it is in your attorney's best interests to get as much money as possible for you and your case. Why is that? It's because your attorney's interests are joined together with yours. Now, what does that mean? It means that your attorney takes your case on contingency, which means he's not working on an hourly basis where he gets paid whether you win or lose. He doesn't get a particular amount of money for every hour he spends working on your case. Your attorney in New York says, listen, I understand you don't have money to pay me an hourly fee. You don't have the ability to give me a large retainer that I can work off of during the course of your 2 or 3 year case. And so what I will agree to do is I will agree to work for you for free for now. And if we are successful, I will have all of the expenses that I put out of my pocket to pay on your behalf to prosecute your case, get reimbursed to me and my law firm at the end. And likewise, if we are successful, my fee will be a percentage of what I am able to recover for you. That is known as a contingency fee, which means that the attorney's fee is based upon whether or not he is successful in obtaining you money for your particular case. And that fee would be whether it comes from a settlement before trial or whether it comes from a verdict that has now been upheld on appeal. So let's get back to the question I raised at the beginning of this video. If your attorney comes to you with a proposed settlement offer based upon initial discussions with the opposing side, now he tells you what the offer is. You may turn around and say, no, that's not appropriate. No, I want more. No, my case is worth more. The important question for you to answer in your own mind, and I'm sure the attorney is going to ask you, okay, if you're not willing to accept this amount of money, what do you believe your injuries are actually worth? And if you are able to articulate and give your attorney an answer to that question, the attorney will likely turn around and say, well, what do you base that information upon? And if you don't have the ability to give an educated answer to that question, now what you are basing that on is your emotion. You are basing that upon information you may have heard in the news. You are now basing that decision upon something you may have heard your neighbor tell you about. Oh, I had a case and I was able to get $5 million for my injury and I only had a fracture. Your injuries are so much worse than mine, you should be able to get $7 million, $10 million, $15 million. And now you are going off of what someone else told you, having a case having nothing whatsoever to do with the type of case that you had. Unless you are able to understand and to know what similar cases have settled for in the venue where you have your pending case, and to know all the nuances of your particular case in terms of the favorable points, the evidence that's favorable to you, as well as the points that are negative, that will likely impact and could have a devastating effect on you and your particular case. You may decide that you are a gambler and are willing to take the risk of going to trial and having 6 members of the community decide your fate on whether or not the doctor or the people you have sued were careless, and whether that carelessness was a cause of your injury. You may think that you have the best case in the world, and you may feel that your injuries are worth 10 times what your attorney believes them to be. Now, nothing is going to stop you from believing that, not even your attorney. You may be shocked to learn that even though you have the best case in the world, even though we have medical experts to support our claim, you don't realize you are now relying on 6 members of the community to determine whether or not the people whom you have sued were careless, and whether that carelessness was a cause of your injury, and also whether your injuries are substantial and permanent. The jury could come back with a verdict against you. They may find that the doctor or the people you have sued were not careless. They may find that the people you have sued were careless, but that carelessness was not a cause of your injury. Or alternatively, they could come back and say, yes, the people you have sued were careless. Yes, this carelessness caused you harm and injury. However, we don't believe that your injuries are worth what you claim them to be. Or alternatively, they could turn around and say, you lose. You get absolutely nothing. In that instance, now you are in a very, very bad position. And then you will have to see if your attorney can find grounds for appeal. An appeal of your matter could take 1 to 2 years, and you don't know what the ultimate outcome is going to be. So, when I asked you at the very beginning, how do you know if you're getting a good settlement offer? Number one, you cannot rely on people in your neighborhood or things that you've read about in order to determine if your particular settlement offer is appropriate. You cannot do that. Now, can you rely on your attorney? The answer is yes, and you should be relying on your attorney since he or she will know the details and the nuances of your entire case. Your attorney will give you the risks associated with accepting a settlement offer, as well as the risks of not accepting a settlement offer. Your lawyer should be going through with you the risks, the benefits, and the alternatives to any potential settlement offer. So why do I share this quick information with you? I share it with you to help you understand how these types of cases work in the state of New York. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.